So we need to talk about what is now happening in the Duncan versus Bonta California magazine ban case in reaction to the Supreme Court's recent 8-1 decision in the Rahimi case. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is First Form. First Form has amazing supplements. I use their protein shake every single day after I work out, but also not only do they have amazing supplements, but they are pro-freedom and they're pro-2-weight. So if you want to get amazing supplements and support an American company, check out First Form using the links down below. And thank you again to First Form for sponsoring and supporting this content. I also want to mention real quick that we have a newsletter available. You can sign up using the links down below in the details section of the pinned comment. And once we reach 5,000 subscribers on the newsletter, we will be running a monthly giveaway every single month. As long as you're part of the newsletter, you will be entered to win. We're going to be giving away various items that are, 2A related. So if you're interested in that, you can sign up using the links down below. Now, as I mentioned in the intro, we have some updates in the California magazine ban case Duncan versus Bonta. You may recall that recently the Ninth Circuit en banc panel decided to kind of fudge some of their rules and take the California magazine ban case immediately as a comeback case. Now, recently, the Supreme Court issued their 8-1 decision in the Rahimi case, and now that Rahimi case and the analysis in Rahimi is being submitted to the en banc panel in the Duncan case as support for why the Ninth Circuit en banc panel should uphold the California magazine ban and essentially find that it's constitutional. The use of the language in Rahimi was something we were all concerned about, and now that language is being weaponized in the Duncan magazine ban case in front of the Ninth Circuit. However, the plaintiffs in the Duncan case are also fighting back against California using that Rahimi language, and they presented their own letter to the Ninth Circuit en banc panel on why Rahimi does not impact this case and does not do what the state of California is claiming. Now, during those arguments, there were debates and arguments about the Ninth Circuit breaking the rules, which was very interesting because in open court, you had some judges going back and forth about whether or not what they were doing was proper. And then there were also some debates about Bruin and the historical analysis and essentially how does that apply to magazines and this ban in California. And then there were also some judges who argued that Duncan should be held until the Rahimi case was decided by the Supreme Court. Now, listening to those arguments, we all anticipated that the Ninth Circuit en banc panel was going to rule the same way that they did prior in Duncan. But ultimately what they did is they kind of delayed this case a little bit, and it seemed like maybe they're waiting to see what happened in the Rahimi case. And now we have that 8-1 decision in Rahimi. Now, in many ways, Rahimi was a very narrow decision, but as you can tell from Justice Thomas in his dissent, he believes that some of the impacts that is going to play out now at the lower court level is a little bit more dramatic. Justice Thomas, who again was the majority author of Bruin, said that the majority was changing some of the Bruin analysis. He believed that the historical evidence that a government would need to put forward as a justification for various bans or various 2A restrictions would not necessarily have to be a twin or a dead ringer, but they would have to point to a single specific historical support that would justify the restriction. It wouldn't have to be exact, but it would need to be in some ways similar. But the majority in many ways said that no, there wouldn't need to be a dead ringer, a twin, it wouldn't have to be identical. Maybe even it wouldn't need to be a cousin law, but just similar in some ways, relatively similar. And then also the majority in that specific decision in Rahimi took analysis from various other historical supports. They took historical support from the affray laws and took historical support from the surety laws and kind of put them together to justify what was going on in the Rahimi case. Justice Thomas, of course, didn't like that. He wants a more narrow approach. He said that Bruin called for a more narrow approach. And then also, if you looked at some of the ways that the lower courts actually dealt with Bruin after Bruin was issued, specifically even if you look at what Judge Benitez did in reaction to Bruin in the Duncan case, in the Miller case, and some of these other bans, they'd also looked at more restrictive historical support instead of just kind of doing this hodgepodge, looking at general principles of historical analysis. They were looking at a more narrow approach. And now we're seeing this play out with the California magazine ban case in the Duncan case because California has submitted a supplemental letter using Rahimi as a justification for why Judge Benitez erred in his analysis. Essentially, they are arguing that Judge Benitez, in his analysis in the Duncan case, was using a historical justification that was too restrictive, kind of similar to what Justice Thomas was, advocating for after Bruin. They're arguing that Judge Benitez and his approach is too narrow, and instead he should have had a more broad, principle-based approach. So in their letter, California states that appellant's right to notify the court of the 8-1 decision in Rahimi. Rahimi reiterated that the right secured by the Second Amendment is not unlimited, does not sweep indiscriminately, and is not a right to keep and carry any weapon whatsoever. The court recognized that some courts have misunderstood the methodology of Bruen and Heller, which were not meant to suggest a law trapped in amber. It criticized the Fifth Circuit for committing the error of reading Bruen to require a historical twin rather than a historical analog. Imposing a test that demands overly specific analogs has serious problems. That is the same error committed by the district court in this case. As the Supreme Court explained, the appropriate analysis involves considering whether the challenge regulation is consistent with the principles that underpin our regulatory tradition. Applying the appropriate methodology, the court had no trouble concluding that the historical analogs invoked by the government were sufficient to justify the challenge law, even though those analogs were by no means identical to Section 922G8C1. Here, the principle emerging from the long tradition of government restrictions and prohibitions on especially dangerous weapons and accessories justifies the challenge restrictions on large capacity magazines. So there you see California putting forward Rahimi as a justification for how Judge Benitez was too restrictive in his approach and how they can actually use various historical analogs to show a principle of banning what they believe are magazines that are dangerous weapons and dangerous accessories. Now, the plaintiffs respond to that and they state that the Attorney General misreads Rahimi, which confirms that California Penal Code Section 32310 is unconstitutional. First, Rahimi makes clear that the government always bears the burden to justify its regulation when it regulates arms-bearing conduct. Rahimi also confirms that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those not yet in existence at the founding. That defeats the Attorney General's contention that this court can uphold Section 32310 without even engaging with our nation's historical tradition of firearms regulations. The Attorney General's summary of Rahimi's historical tradition analysis also misses the critical point. To be sure, Rahimi explains that the appropriate analysis involves considering whether the challenge regulation is consistent with the principles that underpin our regulatory tradition. But the law in Rahimi was permissible because there is a regulatory tradition of restricting firearms possession and use by those found by a court to present a threat to others. Section 32310, by contrast, prohibits law-abiding citizens who have never been found to pose a threat to anyone from keeping and bearing feeding devices that not only enables the quintessential self-defense weapons to function as intended, but are ubiquitous in modern America. And when it comes to laws that prohibit law-abiding citizens from keeping and bearing a class of arms outright, the Supreme Court has been explicit about what our nation's regulatory tradition is and what principles underpins that tradition. The relevant historical tradition is of prohibiting the carrying of dangerous and unusual weapons, and the principles that underpin it is that the Second Amendment protects the possession and use of weapons that are in common use at that time. And then they say because nothing in Rahimi purports to disturb that principle, California's ban on feeding devices that are unquestionably in common use today remains flatly inconsistent with our nation's regulatory tradition and the principles underpinning it. So what's going on right now in the Duncan magazine ban case is very important. You have both sides arguing about what impact Rahimi has on this issue of magazines. If I had to put a bet on what is going to happen, I would anticipate that, of course, the Ninth Circuit en banc panel is going to say in some way Rahimi impacts what's going on here with magazines. They might say that Judge Benitez was too restrictive in his approach, was maybe too restrictive like Thomas wanted to be, and therefore there maybe is some sort of historical principles and something that underpins these types of bans. Now, even though that would be, of course, horrible, that's not the right analysis, that wouldn't be appropriate here, in some ways that could help us down the road because we know that the Ninth Circuit en banc panel is not going to rule in our favor. It's just not going to happen. But if they use Rahimi in the wrong way in this case, that would be very good to set up Supreme Court review because the Supreme Court wants final merits decisions. That's what we're dealing with here in the Duncan case. And if Rahimi is used the wrong way to justify an outright ban on magazines, well, then that would set up a very interesting, cert to the Supreme Court, seeking for the Supreme Court to finally address magazine bans. So again, this is something we are going to want to watch very closely going forward. Of course, if anything else changes, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.